George Saldana here in a minute about a big development in Tarrant County regarding 23, the criminal penal code that relates to interference with child custody matters. When George gets on here, we'll talk about a case in Tarrant County that was recently accepted by the Tarrant County District Attorney's Office, and this could have huge implications for the Tarrant County family court system, law enforcement, and most importantly, how child custody exchanges are handled. In the past, Fort PD has told parents and other law enforcement agencies in Tarrant County, including the Sheriff's Department, have told parents that interference with child custody is only a civil matter. In other words, they were telling parents they had to go to family court to address child custody interference. And now it appears that these law enforcement officials can no longer say that. Another thing that they would tell parents is that the district attorney's office does not accept these cases. So that was kind of a way that the officers got away with not enforcing the Penal Code violation 2503. And, George is going to jump on here in a minute, and we will, if everything goes well, discuss this case in detail. And it came out of Watauga. This case was forwarded by Watauga and accepted by the district attorney's office very recently, and there are a lot of implications for parents here in Tarrant County. So George is going to jump on here in a second, and we'll get started. George, of course, has been working statewide to get public awareness going here. All right, George wants you to join the video. Let me get George in here. Accept. Okay, any second now. Adding. All right, so here he comes. All right, George. All right, we got it.
There you go.
All right, we're set. All right, I gave him a little bit of an intro, but let me go ahead and start again. So there was a really big breakthrough in Tarrant County regarding 2503, and we'll talk about this case that was accepted by the district attorney's office. And again, the significance of this is parents, in Tarrant County have historically been told that that it's a civil matter, even though it is a criminal matter. Basically, they're told to go to court, hire a lawyer, go to court, argue this in front of a judge. Often the judges will not enforce their own court orders. And so this has been a very frustrating experience for parents, and may no longer be such a frustrating experience now that the district attorney's office is enforcing this law. So let's read a police report that I obtained from Watauga PD today, a food open records request, and they got back pretty quickly. I appreciate them doing that. This involves, we're just going to say a mother and father. The mother, we'll say it matches the exact name of a staffer at a Tarrant County district judge's office. So that's an interesting aspect, and we're not quite sure how significant that is, or if that's just a coincidence. But so here's the police report that led to the district attorney's office accepting what we believe to be the first case, 2503 felony, interference with child custody. So the original order is signed by father and mother. According to someone, mother was to have custody of child until 1800 hours on August 6th of this year. I believe its father attempted to contact mother via email, text, and through her attorney, arranging a meeting to pick up child at a specific time at a 7-Eleven gas station located, and has a location. Father never received a response, and mother never showed up at the location with child. Father contacted Fort Worth PD, and they documented the incident. That incident number is not provided. Of course, this is Watauga PD speaking here. Um, and so father contacted Fort PD. That incident in Watauga, sorry, let me get this straight. That incident cannot be provided. Father drove to mother's residence, and they give the address in Watauga. Could not get any response at the door. Father contacted Watauga PD for assistance, and we were unable to make contact either. Um, Father filed a writ of habeas corpus in Tarrant County on August 7, directed to mother, commanding her to deliver child to the court the day after being served. Mother has not been served at this time due to the fact that she cannot be located. The officer goes on to say they instructed father to come to Watauga Police Department to complete a statement and provide copies of the writs and the court order custody agreements. Met with father in the lobby at a certain time. He completed a statement and goes on to say, officer says, I attempted to contact mother via cell phone prior to the filing of this report to facilitate a swap and got no answer. So, and it goes on to list, based on the details of this case, mother is in violation of Texas Penal Code, Section 2503, interference with child custody, and it goes on to give a description. A person commits an offense if the person takes or retains a child younger than 18 years of age, and when the person knows that the person taking or retention violates the express terms of a judgment or order. All right, so I'm going to just almost done here. I'm going to just read one more thing because this is the big part. So, police taking reports, a lot of times they don't, but that's not necessarily the news part of this that's important here. Tarrant County District Attorney's Office has never accepted these cases before. So all the police reports in the world wouldn't have mattered because unless the District Attorney's Office accepts the case, it's, the person will never face criminal charges, right? Okay, so here's the big one. Watauga PD says, on Monday, August 28th of this year, I presented the case to Tarrant County DA's office via text share. I received the following, quote, a charge of incident, and it gives the incident number, has been accepted. And it lists the assistant district attorney's name, and it was accepted on September 1st of this year. And the offense is interference with child custody. Goes on to say that the mother a warrant was issued, mother was arrested, and we can confirm via the district clerk's website that the case was accepted, and now we have a person who's facing felony charges here. All right, George, your turn. Give me your takeaway of what we've listened to just now.
Well, this is a very, very common scenario. I mean, it's not really hard. To me, it's did she show up or did she not show up?
Mm-hmm.
And I'm the founder of Interference with Child Custody, the group, and I want people just to realize one. If you go to 151.001 of the Family Code, it says you have a right to physical possession, being a joint managing conservative. This officer, how he wrote this, is great. It's very well documented, and law enforcement needs to be able to do this. And what strikes me about this complaint is that a lot of parents are going through it, right? They're unable to locate the other parent, so therefore those civil remedies can't be can't find relief. If you can't find the other parent, I've been in that situation where I'm trying to file for a habeas corpus and you can't serve that parent you can't find them, right? And so a lot of these parents, all they want is access and possession. They just want to see their child,
Mm-hmm.
right? They just want that. They're not, they're not doing anything illegal, immoral, or unethical. They're actually following the court order as the judge has ordered in the best interest of the child. When law enforcement doesn't do this, doesn't help locate these children, we go into the statistics that the state has already provided all of us. 80% of children that come out of fatherless households go straight to prison, right? It's the school to prison pipeline. 90% of runaways come from fatherless homes. And these fathers are trying to be there. They're following the court order. there's just so many things in here that a lot of these parents experience every day. You know, the Code of Criminal Procedure, what a missing child is, when the whereabouts are unknown to the child's legal custodian. And I hate to use the word non-custodial, but as a parent, when I show up on the court-ordered possession day as ordered by the judge is telling me, go over here to pick up your child. And if the other parent is just disregarding that order, one, if it's true where she works, you know, it's unacceptable. I mean, there's so many lawyers, there's so many judges you could ask that, hey, you know, I'm having this issue with my ex, and, you know, can you point me in the right direction, you know, for proper relief? You just don't keep the child from the other parent, because now it looks bad not only on you, but also on the office that you coordinate.
I want to touch on one thing because this father, it appears that everything that parents should do in these situations, he went to the family courts and got rid of habeas corpus, but his the mother appears to have hid him, so they couldn't get her served. So that was kind of a dead end, but he did try that initially. Do you see that happen often in these cases?
Yeah. So, you know, it's if they want to keep, retain means to hold back, retention, keep back, like a retention dam. And so if they're gonna exhaust every option, and I think that's what makes parents, you know, the good parents upset, is that we're doing everything correct. We're following our court order. We were instructed to call law enforcement to make a documented incident, and theoretically it should go to court and the judges should enforce it. But we're seeing where judges are not enforcing their custody decree, their custody orders. So then the parent, and in my case, they just keep violating because there's no criminal relief and there's no civil relief. And then you can't find them, and then your child becomes a fatherless home or another statistic of the state. There has to be some sort of reporting requirement. We live in 2023. We get sending people to the moon and to Mars. And you can't tell me we can't effectuate a violation of a court order. I mean, it's real simple. Whether they showed up or they didn't, can you find them? Can you not find them? And kudos to this officer. This officer went over and beyond, because the court order says any law enforcement may use reasonable efforts. He tried to call her. He tried to locate, was unable to, and he followed the law, and they were able to get relief. I mean, it's great.
Yeah, this is how it's supposed to work, correct? I mean, this is an example of how we would hope things would work, where the father or the mother is doing the correct thing, following the decree. Maybe initially, tries to go back to the courts, tries to have the ex-spouse served. When that fails, law enforcement tries to communicate, tries to resolve the issue, right? Law enforcement try to call the mother in this case and get this thing settled without the need for criminal charges or anything else. All that failed because apparently it appears the mother was disregarding everything at every point.
I mean, at some point, we're losing children because law enforcement fails to mitigate these situations. And this case needed a criminal charge. When on some of these other cases, they're real basic. If law enforcement would go mitigate the situation, knock on the door, make the notification, and say, hey, look, you keeping the child against, the other parent, not only is it a felony, but you can also get hit civilly too. You're not going to get double jeopardy. You're going to get a civil hit and possibly a criminal charge as well. So it would behoove you to turn over the child in accordance to the court order. Okay, well, little Johnny doesn't want to go. Well, little Johnny, it's not up to little Johnny. He needs to see his dad. The judge has already adjudicated this in the best interest of the child. So please just turn over the child. I don't want to have to make you a felon by writing a felony complaint. 95% of all of these cases would be done. Law enforcement would have more officers on the street on those first, third, and fifth Fridays because they've mitigated the situation. But now we're just going to keep egging it on by saying, hey, it's a civil matter, don't call us, right? So this officer did a great job. Hats off. Tarrant County DA, I'm glad that they're starting to pick up these charges. And we're not trying to make parents felons. It's just to get from point A to point B. I just want to be a parent. The family code says I have the right to physical possession. It shouldn't be that hard to just turn over the child and do what's right. When law enforcement doesn't do what's right, they allow that parent to just keep offending, and that's what makes parents upset, because there's no accountability. There's then why are you making, okay, so I have to throw this in.
Go ahead. Yeah.
October's Domestic Violence Month.
Mm-hmm.
And just domestic violence in the last few years has added financial. Anytime a person retains financial disclosures or monies or whatever, right? That's a form of domestic violence. They've added it to it, right? Interference with child custody is in the domestic violence bench book. It is domestic violence when you use it. So now, all of a sudden, when these DAs are making these parents go back to court, right? Go back to court for orders that are truly enforceable, right? Where does that not cause a harm to us? Because now we have to pay to be that parent that we have a right to physical possession. Does that make sense?
Yes. And I wanted, for people who are joining, we're talking about a big development in Tarrant County where, for the first time, as far as we can tell, the district attorney's office is enforcing a law on the books that punishes parents who interfere with child custody exchanges. So historically, when a mother or father doesn't allow the other parent to access their child, there have been few, if any, remedies, and they could go back to court, spend a lot of money, probably waste a lot of money. The police historically have said that it's a civil matter. That's not true. The police have historically said that the district attorney's office does not accept those cases. Historically, that's been true, but is no longer true. So we can't emphasize enough what a big deal this is. Every law enforcement agency in Tarrant County can no longer hide behind this statement that the DA won't accept cases, because a case was accepted a couple weeks ago. So what do you think the ramifications are, moving forward? News of this, we're probably the first people to speak publicly about it, is spreading. And so I'll tell you, I reached out to Fourth Police Department, through my media contacts, and asked them, how is this going to affect how you guys handle these cases? Interestingly enough, they said they were going to get back to me, and I haven't heard back. So I think it's a really big deal, and they're trying to figure out, oh man, what are we going to do now? So moving forward, what do you see happening at the ripple effect of this felony case becomes widely known to parents across this hugely populated 2 million person county?
Yeah, I mean, if you want, it all comes down to money, right? And it shouldn't be about money, and to me, this is a good thing. You're bringing parents, not just mothers, but you're bringing fathers back into the household, right? By enforcing this. And then the one thing that gets to me is that they know that these delinquents that are overcrowding our jails are coming from fatherless homes or single parent households. You can go and ask the juvenile courts, for their statistics, and they're going to be about 70 to 75% of all juveniles. I know here in Bexar County, 74% of the juveniles that are incarcerated are coming from single parent households. So if you want to fix society, if you want society to grow and prosper, right, you're going to have children that have a healthy relationship with both parents. Now, again, we go back to 151 of the Texas Family Code, where it says, you have a right. So when Fort Worth PD does not send an officer out, they're denying rights. Right. Yeah. But then 151.003, it also says no law enforcement no state agency may make a policy that would violate the fundamental rights of parents. So when I call, because I'm supposed to, I have a court order, and I have a judge's signature. It's the same judge's signature that would be on a warrant, right? They enforce warrants, but you're not going to enforce my piece of paper. So now you're not going to send anybody. You're going to make a policy that violates me. And then how is that person in Fort Worth supposed to take his tickets correctly before a judge, right? If you're making telephone calls or online complaints, right, that's not proper reporting for the civil courts, because the civil courts have to prove, preponderance of evidence, you know, it's a different standard in criminal. But you go back to family court with preponderance of evidence, right? But you still have to prove that you showed up at that location. If you're sitting on your couch making a phone call saying, "Hey, mom, my ex didn't show up at the court ordered visitation site exchange," right? But I'm sitting on my couch. Well, how do I know you were there? You can't properly seek relief if you're having those types of documentation issues. So again, I've asked my family court judge, what is the proper mechanism for reporting? There has to be a proper way to report these incidents, to take them back, not just to criminal court, but to civil court as well.
Let's talk about the scope of this problem. This year alone, I've had 3 custody interferences for my ex-wife. It's pretty common. You know, if half people are divorced, you know, we have a lot of people that are seeing their children through court orders. I do know in the Tarrant County Sheriff's Department, it's one of the leading reasons they get called. I think a lot of law enforcement agencies, it's a leading reason for calls is people are saying, my ex won't deliver, you know, my child. From what you've seen, because you watch this very closely across the state, how common is this problem statewide?
So when I started this movement, I did a public information request just from San Antonio PD. Just from San Antonio PD. We're the 13th largest city in America. And just San Antonio PD, that's not Bexar County, that's just the city. There was 12,354 visitation violations in 1 year. I think it came out to like 33 a day or 34 a day. But again,
that reported, right? So
yeah,
it's probably more. I mean,
right. The first, third, and fifth, and then you have Father's Day, and you could see it on Father's Day and on Mother's Day. You could see the call volume where on Father's Day it would go up, right, because fathers would be denied, and then on Mother's Day, absolutely, you know, very few violations that were reported. So that's, you know, all these parents, and if DAs and cops are forcing, hey man, I don't know what to tell you, go hire an attorney, but I don't have $5,000. Right?
Yeah, I want to talk about that because a lot of the stuff we advocate for relates to the family court system. And so, you know, what law enforcement across the state has been telling parents, I was told this, you know, is that it's a civil matter. They're saying go to court. So what does that mean for people who don't have a lot of money? Is that even a remedy?
So what I tell people all the time is when cops tell you it's a civil matter because it's a civil order, well, there's no criminal possession and access orders. So the law for interference with child custody says in violation of a court order or judgment, including temporary order. So they're talking about a civil matter, right? They're talking about, and I've done the research. I've gone down this hole. I know why it's a felony. I know why it'll stay a felony. But the important thing is that now we're seeing traction. We started this, or I started in September 1, 2017. I built a group in 2018, and we've carried it. We've done a lot of education. We do education with parents right now and again, we're not trying to make parents felons. I think that's what a lot of people look at me as Big Bad George. He's just trying to make parents felons, and it's not. My objective is to get to my child the easiest, quickest, most efficient way. And if I can't get it done in family courts, then criminal courts is all I got. And if criminal courts aren't doing it, then I've lost out. And now I'm being forced to pay when I have perfectly good court orders, right? As far as what was your second question?
Well, maybe we'll change topics, you know, but the family courts are not, people pay a lot of money when they go through divorce, right? I paid a lot of money for this document, you know, this document is supposed to mean something, but what does it mean when courts refuse? I mean, they're allowing these things to happen across the state. Are these decrees worth anything?
I mean, no, they're not.
Yeah.
I've seen officers tell people, go get me a certified copy. They'll go and get a certified copy, and a day later the cop will say, no, I still can't take it. Cops will tell you anything. to get away from enforcing it. Oh, I don't want to touch it. But at the same time, these decrees are printed on paper and are signed by a judge, just like any other warrant that's executed by law enforcement, right? Why should I have to keep paying for that same piece of paper, the same signature,
Exactly.
the writ of habeas corpus, the possession and access? This guy just spent all this money when, if Watuga would have said, hey, from the get-go, we wouldn't have needed a habeas. And plus, they wouldn't have problems finding her months down the road, right? If they would have executed this, and I'm not saying Watuga personally, but I'm just saying if law enforcement would have mitigated this from the get-go, this man wouldn't have had to pay all this money, right? And even the habeas corpus that's supposed to command her to bring the child, like he's going to have to pay his attorney for that. And of course, the attorney might get his attorney fees out of it, right? Because
he probably spent a lot of money just through that step. And that's a good point. He really didn't have to, but he also didn't know that the DA would have accepted the case, right? But now that we know that, one bright spot that I think we can take away from this is that the family courts are incredibly expensive and corrupt and inept. And anything people can do to avoid having to engage with that system, I think is a good thing for parents.
I mean,
what do you think?
Real quick, if you buy a car and it's 20 years old and it works for you, it starts, it goes from point A to point B every day, there's a lot of fathers that would be okay with extended standard, right? There's a lot of fathers would be all right with not having 50-50, but they have to ask for more time because of the games, and I'm not saying that fathers don't love their children as much, but you're right. When these courts don't enforce their orders, you're making me buy a new car. My car is
That's
fine.
A good point.
My vehicle is fine. It gets me from point A to point B, right? I'm okay. My work schedule allows me to work this visitation or possession and access period like this. I'm okay with it, right? And most fathers are, but then now fathers got to take a bigger chunk. Well, now I want 50-50 or I want sole because the standard possession isn't working because she's retaining from me, right? So now you're making me modify. You're making me go hire an attorney, one, to locate my child, which I should never have to do. You should never have to locate your child. Again, missing child says the whereabouts are unknown to the child's legal custodian. And a lot of people misinterpret that as saying, well, you're the non-custodial, so the child is with the custodial parent, so it's not missing. At 6 o'clock, that judge has ordered me to take custody, possession, and access of little Johnny. And if I don't know where little Johnny is, you go back to 151 of the family code, right? Care, custody, and control. I have the right for physical possession, care, custody, and control. If I don't know where my child is, there's a problem. I'm here. I'm ready to parent. This is what the judge told me to do. I'm following the orders. But then that doesn't satisfy the family courts, because then the family courts say, well, get 3 more violations and then come back, and then maybe we'll hold her in contempt. And then after that, we'll put her on probation. And if you're in my case, they put my ex on 10 years probation. She's still doing it, and the civil courts aren't doing anything but making me out to be the bad man. And I'm just telling people, hey, look, court orders are written and they're signed by a judge. You have that right to physical possession as per the family code. The cops know the family code. They're taught some of the family code because it pertains to protective orders. So when they say, well, we don't know the family code, it's BS. The family code 151, carry it in your wallet, guys. I have the right to physical possession. Just like you have the right to free speech.
For anyone joining us real quickly, a big development in Tarrant County, the Tarrant County District Attorney's Office has accepted a case for interference with child custody, which is a felony, and that matters because there are tens of, this is a huge issue across the state of parents not being able to access their children, even with court orders, and it's a huge deal that the District Attorney's Office is actually enforcing a law on the books George, across the state, how rare is this, to see criminal charges
Um,
brought?
we in our group, interference with child custody, we have a Facebook
Hmm.
page, and then we have a semi-private group. And our group and our page together, we've been able to get the word out. And in
Hmm.
2017, I believe, or 2018, I believe, I had heard of just one.
Okay. Wow.
Yeah, in 2017, I had just heard of one, and that came out of Killeen. There's been a few others, and then now it's getting
And we.
better. And especially to see a big metroplex, Tarrant County, because then Dallas County and Collin County are going to follow.
Mhm.
Harris County, we can't. I've seen a couple in favor of a woman, but not in favor of a man. In Harris County. In Bexar County, I know of one gentleman here that has gone all the way. Now the Bexar County DA is taking them, but they're starting to fail at the grand jury. So we're seeing them. We're seeing more and more offense reports being taken, especially here. I've been involved with probably 15 or 20 here in the Bexar County area, getting offense reports and through SAPD. But this is a big change for Tarrant County, because I hadn't seen too many Tarrant County offenses for interference come out.
Kyle French is asking for the report number. And I'll get you a copy of this stuff. It's all publicly accessible, so this is all public information. So Kyle, if this isn't useful, I'll send you the information directly. But it says CID number 0670413. Yeah, again, 0670413. You can look that up on the district clerk's website. SID. Oh, actually, I'm not sure if let's not say that. Prosecutor case number 839-088 in Tarrant County. And again, if anyone wants specific information, we'll get you that so you can review this. You can review the police report that I got. They sent it pretty quickly. Again, I requested it through Taga's Open Records Department today, and they sent it within a couple hours. So it's very rare that we see a district attorney's office accept this case. And let's talk about why do you think that's been, and what do you think has changed?
Other than the education that we provide on our pages to help parents, this legislative session, there was a few bills passed that are demanding.
We'll talk HB 17. Let's talk about that actually.
Yeah.
Mm-hmm.
Holding DAs accountable.
Mm-hmm.
And that's something that, where do I start?
It's a breakthrough because your group has been doing so much work.
Yeah.
And it's just kind of, I guess there's a little bit of serendipity that, this House bill just happened to be. For folks who don't know, HB 17, which is now law, allows people to remove district attorneys if they don't enforce the law, basically.
Yeah.
So they can't selectively say, we're not going to enforce this law ever. They have to treat each law in the books as a valid law. Is that a fair summary?
Right. Supposed to.
Mm-hmm.
And, where this journey took me was straight to the DA. And I'll tell you that there's a lot of big egos in the DA's office. Before this law, they felt they were untouchable. Their attorneys, you can go to the state bar and file grievances, but that's a roadblock because, the state bar doesn't punish anybody, especially when it's coming from a civilian. So holding a district attorney is holding them accountable is very, very hard. You could put public pressure on them, but I think this gives us that mechanism that I was talking about. The opportunity for little people like us to be heard. And this is something that I will be looking into for Harris County.
Yeah, because now you can use the House bill, if you know what I'm saying, because you can force things. You can say, if you guys don't enforce this law like Tarrant County is, we can have you removed now, correct?
Right.
Okay.
And it's a shame it has to even get this far.
Yeah.
Ed and George and a few others are just wanting to see their children, right? And now we're having to find other avenues to circumvent the the mechanism of reporting now, because it doesn't work. You know, they want to hold us to account. They want to hold us accountable. They want child support. They want all the benefits from you, right? But then when you ask them, they want your
Oh yeah.
taxpayer money, right? But when you say, hey, look, my taxpayer dollars pay for that judicial robe, and you're
Mhm.
supposed to enforce these decrees, you know, my taxpayer money pays for this DA. He's supposed to take these laws. These cops are supposed to, you know, take these reports. But once Ed slips up, they're going to come get you.
Mhm.
And it doesn't need to be that way. You know, all we are, again, are just parents that just
Want
want
to
to
be
be,
parents?
yeah,
Yeah.
just
Yeah.
want to be parents. But it's a $60 billion industry.
Mhm.
And if you think about it, that's all really lawyers and fight about is possession and access and child support.
Yeah.
Those are the two things that are most common in family courts. Yes, you have the traditional divorce and fighting over property and discovery, but a lot of it comes from possession and access and child support. Enforcement, jailing somebody, and all the money that comes to the county um, because of financial and state grant money, the incentives.
Do you think that fourth PD, you know, they can no longer tell people that they can't file these cases? Are you optimistic? I guess it's just on the public. The public needs to create more awareness in that that they can now go to the police and they have to take these cases. So, what advice do you have for people in Tarrant County now that Tarrant County has, you know, kind of you know, broken the dam, so to speak? What do they need to do the next time their ex violates a court
I mean,
order?
look, I've always told you, record it. Everybody's recording. That's the first thing you can do. You can record them telling you no and then take it to internal affairs, right? You can look at Fort Worth PD's policies. And I can tell you right now, one, their policy of denying you the ability to call an officer to report that is one of those policies under 151.003 that violates your fundamental right to be that parent. Two, stick together, or three, stick together. Stick together. The more parents together, if there's five of us telling an officer, hey, you know, you need to take this charge, look it up in on your penal code book or your app or the penal code on your phone, look it up, charge it. I haven't seen my child in this long, right? There's no reason parents should be saying, hey, I haven't seen my son in 7 years because I don't have money for an attorney, right? Give him the basic dignity of that court order that he has at 7 years so he can have a meaningful relationship. When people come together, and that's what I've done, is I've built a team. I've made parents come together. I've educated them. And I said, look, we can do this. And so now it's starting to work. More parents are educating more. You can't go over there to PD and just demand interference with child custody and then not know your rights. Right? So you have to know your rights. Just like I said, 151.001 of the Family Code, that's the first right you should know. I have the right to physical possession. That's where it's going to be your purchase point to open this all up. If she's not here, you need to know about welfare checks. You need to know about what a missing child is. And again, I'm going to say it again, no parent should have to ask, where is my child? If any parent, court ordered, not court ordered, right? Any parent says my child is unaccounted for, I want
Apologize.
to know. That's that right
Yeah,
there
sorry. No.
strikes me all the time. You know, no parent should ever have to ask, where's my child? And no officer should say, go hire an attorney if you want to find your child.
And there's a Facebook group that I'm a part of. I'll go and plug that, but it's really heartbreaking to hear these messages because every time someone posts, they're basically saying I was supposed to have my child today, and they're looking for advice, and you guys provide good advice. But you know, talk about some of those stories and some of the advice you give they give fellow parents.
Yeah, I mean, it's not legal advice. The advice that we give is how to basically file a criminal complaint. It's not really brain surgery, right? To make a criminal complaint, someone steals from you, you pick up the phone, call 911. That's what was drilled into you as a kid for emergencies, or you need police, fire, or EMS, call 911. Call them, tell them, hey, look, there's an infraction of the law here. This is what it is. This is what I have as far as documentation. It's not real hard for a competent adult to make a criminal complaint, or just a complaint that's going to go somewhere, that they're going to see relief. But, you know, there has to be a healthy balance. I understand there's allegations. I understand false allegations. You know, parents that are using false allegations to keep the child. That needs to be implemented too, right? We need to have some sort of reporting process when they make false allegations or a false report, and that right there hurts a lot of parents, because then you roll into a protective order, and then you go into temporary orders, and then it's a cycle. It's all a cookie cutter cycle, how things are done in family courts, right? Now he's harassing you because you're coming to get your child, right, at the court ordered possession. I got arrested for criminal trespass with a court order trying to pick up my child. The judge ordered me to go there, and you're criminally trespassing me. Come to find out, the DA dropped it 2 years later, right? There was no case.
Folks are talking about the district attorney's office accepted a case for inappropriate child custody, which is significant because historically the DA has not accepted these cases, and that's left parents with basically no option other than maybe spending thousands of dollars in court. So it's a really good thing. Hopefully, it leads to more positive situations where parents don't have to go to court. As news spreads of this, hopefully other parents are put on notice that they could be criminally charged if they don't allow their child to see the other parent. George, we can't talk about inappropriate child custody without talking about parental alienation. What is the mindset of these parents who think, in some way, I'm sure they justify this in their own heads. It's really quite sick, to even think about keeping your child from seeing the other parent. But, what is the role of parental alienation in this? There's usually alienation going on by the time a parent believes that they have the right to keep the child from the other parent.
Yeah, that's what I say is the foundation.
Yeah.
That's what I say is the foundation. That's where it starts, Little Johnny's got a basketball game or a football game, and he doesn't want to go with you. Now you're letting that child disrespect your ex's parental rights, and then it seeps in. It seeps in so bad that now the child starts talking back. And I can positively personally talk about this because I've had my two older children are that way with me. I can't parent them. I can't take their cell phone away. If I do, it's child abuse. Call CPS. Dad hurt me because he took the cell phone away. Right. And if I don't, then the behavior continues.
Yeah.
Right. So parental alienation, that's the foundation, and that's how it starts. Is your dad doesn't want to see you. Your dad's this. Your dad's too busy. Johnny's got a game. He doesn't want to see you. All of that. When all of that starts spewing out, that's when it starts. And then now cops are involved. Cops are saying, "Hey, look, you need to turn the child over." Well, little Johnny doesn't want to go. And so let me clear up a myth. One of the myths out there is that, and we hear officers say it all the time, well, when the child's 12, they can decide whether they can go with mom or dad. And that's absolutely false. At 12, they don't get to make that decision. 12 talks about conferring with the judge in his chambers.
It's very specific.
Right.
And even then, the judge still decides.
Right.
So.
And so a lot of these law enforcement officers are giving that child the option to make that decision, right? A child is governed by that court order until the age of 18. A child can, at the age of 12, can't say, "Hey, I'm going to go get a pack of smokes and some beer," and and you can't tell me anything, right? You can't take my cell phone away, right? What's reasonable discipline? A lot of these terms aren't defined in the family code, and so there's a lot of since it's vague. There's a lot of, and then you got to know that the standard of proof is preponderance of evidence. It gives that judge wide discretion, and basically it sets people up to lose. So some of these words need to be clearly defined, just like best interest of the child, what is reasonable discipline. Those words within the family code need to be defined, so parents are able to parent these days, because we can't do anything. We can't pick up our child. We can't tell them, no, you can't go. They run out. The generation, and everybody talks about Generation Z, right? They're just all over the place, is because we've taken the disciplinarians out of the household. Dads are usually the disciplinarians. And when dad says no, it means a little bit more. And so, and I know I might catch some, stuff for that, right? But I think you need to have a mom's love, care, nurturing, and you got to have a dad's firmness and tough love, to equally balance a child. And when you let a child just over or supersede a parental decision, you're saying it's okay. And that right there, it's now the child's going to have problems with authority. He's going to line up, or he's going to end up in jail or in prison. And then he's just not going to respect anybody. So yeah, parental alienation is bad. And I wouldn't wish this on anybody and their children.
Yeah. And we've all experienced this, George. Unfortunately, we know you're still separated from your child unjustly, but it's extremely painful to be excited to see your child, to know you're about to see your child. You haven't seen your child in weeks or maybe longer, and then at that very moment, where you at that 6 o'clock time, you get that sick feeling in your stomach because you realize that your ex had to drop the child off. And then it's 5 minutes later, and it is the most sickening, feeling that parents, can feel. And it's because the other parent has disdain for the court order. And of course, I could talk about the ethical and moral issues, but they're showing, I should say, contempt, for the court orders. And the family courts historically have done nothing to protect those rights. They have completely abdicated their role in this. And so what we're seeing is hopefully, again, a positive change where, law enforcement is now becoming involved. We don't know exactly what was going through Phil Sorrells's, District Attorney Phil Sorrells's head. He probably signed off on this because it is such a big decision to have Tarrant County, accept this case, because it's going to set a precedent, across the state. It's going to, set a precedent across our county. And I think part of his calculation, it might have been HB 17, but I think part of his calculation is the work that you and your group have done, and the boisterous, parents out there who have demanded that some part of our government take responsibility for protecting our sacred rights as parents. So we hope that this leads to more parents making the decision to follow these orders. Folks, if you're dealing with, child custody exchanges, you can now, show this, report, and you can, if the police officer says that the district attorney's office does not accept these cases, we will provide this information, for you guys. You can read it to them that this case was accepted by the DA's office. It's on the district clerk's website. There's no going back on this. And I think, for people who have been really frustrated with the family court system, this is positive in another way, because hopefully long term it gives people an option to bypass the court system entirely, and to see that system have less money, because it's all all the problems that we're seeing in the family court system is fueled by massive amounts of money that parents have to pour into it. Do you see it as a good thing that now we can go to the police and not have to hire an attorney and bleed in this court system?
And again, it's just like the car analogy. If I have a working possession and access, I'll tell you right now, I didn't go for full custody because I just wanted to be spiteful. I just wanted to take my son. And now I have to go for full custody because she's unable to follow the court order. They send her a target letter, and just to give you a little bit of the background and rewind it a little bit, when we started in 2018, there was 5 of us that met with the lawmaker who legislated it in 2011. That's Richard Raymond, and down in South Texas, in Laredo. And Richard Raymond, Representative Raymond, set us up with the District and County Attorneys Association here in Texas, and we all met in the Capitol. There was about 50 people in that room, and there was about 7 DAs from across the state of Texas, and they were Austin, Travis, Bear, Nueces, and a couple others. Smaller counties, Coronel County, and another one. But we went over this. And so the DA's Association came out with a write-up about it from the Guadalupe County was the last county. Guadalupe County. And Guadalupe County DA at the time, Mr. Wilborn, wrote an article on it, on how we had this meeting and that how some of these stories where we hadn't seen our children in so long, that the stories that he had heard needed to be addressed, and that there was times when the DAs had to get involved. And that meeting, it meant the world to me, because it told me I wasn't wrong. Everybody, when I started this, everyone said it's a civil matter. You don't know what you're doing. You're wrong. They gave me every excuse. They'll never enforce it. There's too much money. You're going down a deep hole that you're not going to be able to come out. Don't even start. And when I got clarification that all these DAs say, yeah, it's a felony, but then there were some in there that were like, no, we're still not going to enforce it. And I still couldn't believe it, but at the same time, I knew I was on the right path. And again, it goes back into everything you were just saying, right? If you have a perfect vehicle to get you from point A to point B, why do I need to buy another? Why do you got to keep selling me a warranty for that vehicle when I have a perfectly good court order? You're selling me another court order that ain't worth squat. This one that ain't worth it. Now you're going to sell me another one? And to me, like, that's a financial abuse on me. That's taking from me. It's robbing the child of the child's fundamental right to his parent. Right? So it all starts at law enforcement. There's a lot of law enforcement officers that are divorced. There's a tradition there that says, well, just take it to court and do it like I did it, the correct way, because I'm the law enforcement. Those egos need to stop. The egos, the arrogance, all of that stuff, the targeting of parents just wanting to spend time. There's parents, I've seen a couple of your guys that have been retaliated against. They're in Fort Worth for trying to file this report. Right now they're being retaliated as harassment because they're telling the law enforcement officers to write up the law like it says.
They were punished.
Right. And now fathers are being punished by law enforcement. And we've seen it in El Paso. We've seen it here. It's happened to me personally. I was taken for criminal trespass. So now fathers are actively, or parents, because I shouldn't say fathers, because I know mothers that have been actively targeted. And now I don't understand how law enforcement can hold themselves up each day and say, hey, I threw a parent just trying to be a parent in jail.
They're criminalizing us for wanting to have the right to be a father. And it quite literally so. I mean, this gentleman, we reported on him through the Fourth Weekly. He was charged with harassment, and it was probably because he was demanding that these 4 police officers enforce 2503. The irony is, weeks later, 4th PD, now has to accept these cases. And I wonder if that's part of the reason why they haven't responded to my real basic question. How is this going to change, how your officers handle, are you going to start filing these reports with the DA's office?
So can I say a few things about that case? Because I was actually in it.
Oh, I know.
So I know the individual that we're speaking of. So in the Code of Criminal Procedure, it tells you where a felony should go. All felonies shall be forthwith before a magistrate of the county. All felonies shall be forthwith before a magistrate of the county. I memorized it.
Uh-huh.
right? That's from the DA. And if you look at the bottom of it, it tells you in 1965, that's when it was legislated. Then they came into this prosecutorial discretion by the Supreme Court, gave us authority to use prosecutorial discretion. Well, I understand that case law gives you that prosecutorial discretion, but the state law says all felonies shall be forthwith before a magistrate of the county. Now, with that being said, the DA can't just say, no, don't send me no felony reports. Stop. Interference with child custody, we're not doing those. I understand prosecutorial discretion. Prosecutorial discretion means you actually have to read what's going on in the case before we can decide whether we have a case. And
sure, they don't want to waste the
fair
time of the government resources on a case that a jury would not find them guilty on. That's reasonable. Yeah.
Right. And so now you telling them, hey, look, we're just you. And again, it goes back to 151.003. No state agency may have a policy in violating a fundamental right of the parent. Right. So with the felony, right, it has to go before a magistrate or else, right, you have to review it. So that individual, we came up with an affidavit and we gave it to Internal Affairs. Internal Affairs, the guy didn't want to give him a criminal complaint because he was Internal Affairs. Never mind that he's still a peace officer, right? He still has a duty of a peace officer, even though he works for Internal Affairs. But he just said, hey, call out another officer and he'll write it. The gentleman called another officer. The officer still denied him, even after the Internal Affairs. So again, it's the cat chasing its tail, right? Now they're sending parents on these goose chases instead of just doing what was right. So the affidavit, now, again, and this is something we offer to parents, is when you write a criminal complaint affidavit, right, you're allowed to give it to a peace officer. It's still a criminal complaint, right? If you want to go and get it notarized yourself, you have that ability to give it. And if you're charging the commission of a felony, you can give it to a police officer. There's no law that says you can only verbalize a criminal complaint to the officer. Most policies will tell most law enforcement agencies, their policies will say that they can't tell a citizen, or they can't discourage a citizen from making a criminal complaint, right? So if I'm giving you a criminal complaint affidavit charging, that goes on the police record that they're there for you, the incident report, right? So if George Saldana gives a criminal complaint affidavit saying, hey, look, I'm charging the commission of 2503, you're supposed to report it, you don't report it, let's take it to Internal Affairs. That's what we did with that individual. And still, Fort Worth still didn't want to do anything with it. So now if we do public information requests on those documents, his criminal complaint affidavit should be there. Now, again, why are we doing things to circumvent the traditional way of filing complaints? It's because there's no mechanism. There's no mechanism to report. And that's what parents are having to do, right? They don't have any money. So now they're scouring law books looking for loopholes just to be a parent.
They shouldn't have to. And there's also a complaint you can file if someone refuses to report a felony. You can actually compel the police officers. So, what is that?
So again, failure to report a felony. Failure to report a felony is a Class A misdemeanor on the state level. Misprision of a felony is the federal charge. So both of them run hand in hand. Now, there is a little word that says "and" at the bottom of failure to report a felony, right? But it goes in hand with their policy, and it goes in hand with a felony complaint shall be forthwith before a magistrate of the county. So by policy, by law, and by law directive, or the law prescribed by the Code of Criminal Procedure, where that felony is to go before a magistrate, right? That tells everybody everything that they can't deny you a felony complaint, right? They can't deny you a felony complaint. There's no other felony on the books that they don't enforce, just this one. And why is that?
What is it?
My tinfoil hat says because they keep feeding the family law guppy fish, right? If the lawyers took on all these cases, not only would they be swamped, right, but they'd be taking off the lawyers, the family lawyers that file all these enforcements.
Yeah,
that
sure.
then take them into a temporary restraining order, then take them into a modification, that take them, right? It pulls them in to litigation, right? But again, if law enforcement hit this from their angle and law enforcement were to mitigate it out in the field,
Yep.
law enforcement would get more patrol officers on the street. They would get less time messing with angry Ed or angry George about seeing their children,
Yep.
right? There would be so much more benefits to the law enforcement agency if they handled this correctly the first time, and then they can use their officers wherever they want in the city because they're not tied up for 45 minutes listening to a parent wanting to be their parent, right? Being the child's parent. It's a no-brainer.
Yeah. And I don't think it's going to take many criminal cases to get the word out, even across Tarrant County, that this is going to be taken seriously, right? You just need to get a few out there, and the word's going to spread. And then hopefully, behaviors change, and people don't have to, waste their time, with our horrible, family court judges. So for someone who's spent, years, advocating for this, are you optimistic that we'll see more, DAs, take this seriously and enforce the laws on the books?
So that was the plan the whole time.
Yeah.
When I started this, I came up with the plan. Let's flip one county, and once we flip one county, they're all going to start flipping, like the domino effect, right? And so we worked hard in Bexar County. We approached, we went to re-election campaigns. We went to, we went to all sorts of political campaigns, and especially during political season, right? And start asking and inquiring and talking to others. And there were people that shunned us away at first because it's bad business for the law industry, family law industry. But then there were some that embraced us, and we're forever grateful for them. We still have our friends that support us because, like you said earlier in this live, that a lot of people deal with this. It's not just subjective to civilians outside the family court system. There's people in the court system that deal with this. In one of my last hearings, we had a bailiff come yelling at me. You don't know this about me, but I haven't seen my son in 12 years, and I deal with it. And I just deal with it. Even the bailiff, he has all those legal resources at his fingertips, judges, attorneys.
Wow.
He could seek relief, right? But he's given up. Give up. They don't have a reporting mechanism. The family courts aren't enforcing, so they lose. There's no mechanism to reporting. So again, the DA taking this on, it shouldn't be about male or female or fathers or mothers or grandma and grandpa. It shouldn't be about that. It should just be what's right. What is right? And I have to stay true to myself, and when I help educate people, because when they tell me, hey, look, can you tell me how to keep the child away? Like, because I know the ins and outs of it, right? But I'm not going to give information where it's going to help another parent keep the child away, right? We want to do this in good faith. Everybody should be practicing in good faith. The lawyers, the judges, because at the end of the day, it's not about them. It's not about their Louis Vuitton purse or their Lexus car. It's on the head of our children, my child, right? You making money off my child, his mental and emotional, and you're willingly doing it, I think parents should ask for reparations from the state. That that SCJC knows these judges are willfully denying these and they're breaking the law. You look at the SCJC on their website and they say, judge didn't follow the law, judge didn't follow the law. We live in 2023. We all have computers, iPads, cell phones. We can look up the law and read it right then and there, right? There should be very minimal, we should have very minimal reporting about judges breaking the law because we have every resource at our fingertip. The Code of Criminal Procedure, the Family Code, the Criminal Code, Government Code, it's all on our iPad. So when you're mandating that a parent come back to court, you're mandating that a parent participate, right? When he was following the order, yes, you can get attorney fees. Yes, you can do that. But the parent doesn't get the attorney fees. The attorney gets your fees and the attorney fees. So he gets paid twice. But you're still broke.
The whole system's messed up because it places the burden on the parents who was following the rules. They're the ones that have to go to court to beg the court, to enforce their. It's messed up. I want to give people, another reason to have some hope. Friday I'm going to talk to a civil rights attorney in California. Filed a massive and really well-written lawsuit against the family court system in California that is looking to hold these judges to sue them monetarily for every day that these parents were without their children. And a lot of these are a lot of cases that we've seen, similar ones here, like yours, Brooks McKenzie, Rustin Wright, where parents, lost access to their children, some indefinitely. And this lawsuit, digs into the constitutionality of the family courts and kind of the basic legitimacy of the family courts. This attorney, I don't want to speak for him, but I talked to him today. And one thing I took away was, parents have a fundamental right to being parents. And the courts really should just be there for divorces, divvying up money. And the second that they engage in, terminating parental rights, they're stepping outside of their bounds or even meddling in our parental rights. And so anyway, it's a massive lawsuit in California that's got a lot of attention. And he told me that the one article that they had, and they're going to have many more, the server crashed because it had so many people, because Disruptive Media shared this information, and there was an article that went along with it. Anyway, several 100,000 people have clicked into this this small blog to read it. Crashed the server today. So people across the country are looking into this lawsuit. And he said, basically someone in Texas needs to, an attorney in Texas needs to take what I wrote, just cross off California, right in Texas. The same crap's happening here. Same constitutional violations, and sue the hell out of these courts and ask for damages.
Yeah. Reparations.
Yeah.
My child is gonna. The state has paid for this research already. That's the attorney general has paid for this research. Mm-hmm. Like, this isn't research from just an independent, right? The state went and paid this with state and federal grant money. And we know that. And we've shown it to legislators. Like, this is the state of Texas done at UT Austin on Red River down the road at the LBJ library. Mm-hmm. Right? This is y'all's numbers. And yet nobody wants to take those into account. And so now the state knows, because those are your numbers. The laws say I have a right. Those are your laws, right? We elected people to go in and legislate it, and those are your laws. I didn't write them. Y'all wrote them. Y'all agreed. And y'all aren't even playing by the rules. Y'all are telling us to play by them. So at what point is that not oppressive? I don't even know the rules to the game. I think I do because I'm reading them. But now y'all are telling me, no, it doesn't go that way. You're not an attorney. You didn't go to law school. George Saldana doesn't need to go to law school to be able to read and comprehend and put two and two together. Legislative intent is how the law is written. So I know you can't change a felony into a civil matter.
Yeah.
right? Legislative intent. You want to pull that case law again, that you have prosecutorial discretion? Boom, let me throw my case law, right? All felony complaints shall be forthwith before a magistrate of the county. Let's go. 1965. Your policies don't supersede state law in 1965, and it's not my problem that you didn't legislate it to fix it how you wanted it done.
Mm-hmm. So,
And that's
yeah,
what I'm seeing, and that's another thing that is in family courts. A lot of these judges, they are judges because they ran an election and they won and they took they got a law degree, and right. But if you go back, and I've been talking about this, who are magistrates? The law says who are magistrates. Legislative intent is how the law is written. There's case law that says who are magistrates. So if we don't have a mechanism of reporting on the criminal side, interference with child custody, file it in. I'm telling people to file it into your family case.
Oh, yeah.
File all your criminal complaints. There's still a judge. Well, the courts divided.
Mm-hmm.
The courts, it was around 2009 in Harris County. The court said, hey, y'all go to civil, y'all go to family, and y'all go to criminal. They were all district courts. Some of the smaller some of the smaller counties have one district court, and they have a magistrate. He hears criminal and civil. But as defined by their rules, the Texas Constitution, who has jurisdiction? If you have quasi-criminal jurisdiction with the enforcements, right? They're quasi, they're civil and criminal. Then you have criminal powers as a magistrate,
mm-hmm.
as defined.
Mm-hmm. That's interesting.
And these judges,
the family court judges witness criminal acts all the time, and sometimes they're the ones committing it. But
again, and I tell people this all the time. We knew it was happening. We knew it was happening before COVID. Mm-hmm. After COVID, we could show it was happening because now we had Zooms. We could see people were
mm-hmm.
reporting. People were showing the courts acting bad.
Mm-hmm.
And so now, guess what? Everybody's got a cell phone. Everybody's got a TikTok. Everybody's uploading it. And now I'm seeing, and that's how I met you. That's how I met Brooks. That's how I met Rustin. That's how I met all these other folks. It's because people started saying, hey, that's happening to me too. Or my brother's having an issue. Can you help him? My aunt can't see her child. Can you help her? 60% of marriages are ending up in divorce. Everybody knows somebody who's being either kept from their kid, or maybe there's a deadbeat out there chasing them for some sort of problem. Child support, mm-hmm. possession, and access. Mm-hmm. Everybody, right? But at the end of the day, it's real simple. Your law, 151.001, you have the right to physical possession as a conservative, right? You have the right. You're an equal. We live in a world where everybody is worried about what gender you are, and we're supposed to treat everybody equal. That's the right thing to do. But then again, automatically, if you're a non-custodial, you're labeled as the bad parent, right? You shouldn't have access. And that's why I tell people there's not a non-custodial or a custodial defined in the Texas Family Code. It's conservative.
Well, we have to have non-custodial to charge child support, so they figure that one out. I want to kind of, wrap up here, and, we'll have to revisit again. There's a lot of different topics we could explore. I want to talk about Rule 12. I had a little breakthrough today. I want to give folks some advice. If you're following Rule 12, we had Judge Jesse Navarez was refusing to release anything. And so I figured out, I'm going to start asking for emails that I already have. And I'm going to put them on notice that I'm asking for this document, but I have this document in my possession. If you don't hand it over, I'm going to send it with my appeal to the Office of Court Administration, and they're going to see a pattern of you withholding emails that you're supposed to be releasing. And sure enough, he released it. So just a little advice there. You shouldn't have to go to these lengths. They should just follow the law. But
like they would probably get rid of us if we just if they just did what they were supposed to do, right?
Oh, it's, all we have to do is follow the law, and we're going to go away.
Yeah,
But until then,
it's not like we're asking you to do anything
no,
illegal for us,
nefarious.
right? We're
Oh my gosh.
just treat us
Um,
equal, you
yeah,
know.
yeah.
But they
Do
they
your job.
yeah, they because we mandate they do their job, they're upset with us.
But yeah, we're going to get together and explore some other topics, George. I just want to close by saying that this is a really big deal. Um, Folks, anyone out there who gets told that the district attorney's office does not accept cases for 2503, that was true before September 1st, 2023. That is no longer true. And you can show them, this police report and read it to them. You can even tell them which prosecutor accepted the case. Things have changed, in Tarrant County for the better. And, George, it wouldn't have happened, I believe, if you and your people hadn't been pushing for this. So I want to, thank you for what you've done. I think it's going to start making positive change in Tarrant County. So
Hey guys, on a ending note, you can find us on Facebook. We have a page. We have a group, which we do most of our talking and strategizing on. It's semi-private. Don't come in here thinking that you're going to not be able to, your ex might be following you in there. Again, we're not doing anything illegal, unethical, or immoral. We're asking everybody to follow the court order after the judge wants you to. So, and then we have a TikTok. It's at Texas 25.03. We have a YouTube, an Instagram. We can be found there. In closing, record your interactions with law enforcement. I'd want you to record, because then you'll be able to take that to internal affairs and tell them, hey, look, I'm just trying to gain access to my child. The officer's supposed to report it. Your policy, their policy is to have law enforcement take a criminal complaint if a criminal action has occurred. Record. Also, find out the name and the badge number of the officer, and then again, take it to internal affairs. And then after that, contact us, and we'll guide you the rest of the way. But again, Eddie, it's always a pleasure. Man, we should do this more often. We could.
we're kicking butt, and I can't wait to Friday to talk to this civil rights attorney, and we'll publish that maybe this weekend. And I want to get some useful advice, for folks who want to sue the family court system. How do you do it? He's doing it in California. We all think that these judges are untouchable. My friend Stephen May, reminded me that they're government employees, judges. They're not people that are to be worshipped. They're government employees, just like anyone else who works for the government. They're paid to do a job, and we can demand that they do what we ask them to. They work for us.
They're public servants, and we're the taxpayer. You wouldn't expect a law enforcement officer who you're paying to do something wrong, or a firefighter, or anybody that's on the public's dime, right?
Yeah.
So we have to hold them accountable. They are supposed to be accountable to us. They ran that they would uphold the Constitution and the laws, and we need to make sure that they do it. I mean, we're not doing anything wrong. We're reading the rules that they legislated for us. So
yeah,
I don't know.
And because you, less parents hopefully will have to go to these cruddy judges for anything. So thanks again, and folks, if you missed the whole show, go back and watch it. There's some good stuff in here. We appreciate George making time to talk to us. So, all right,
man. Thanks for
having
having
Till
me
next
on.
time. Thanks for watching, everybody.
All right, later.